Thank you for watching this video called Trademark Myths Busted. Hope this video is very informative and provide you with useful information. My name is Xavier Haley, and I'm a registered patent attorney with the United States Patent and Trademark Office. I practice law in the area of intellectual property and business law. So let us dive into busting these myths. Myth number 1. I have registered my domain name, therefore I am protected and no one can use that name. Registering a domain name does not grant trademark rights. Trademark rights are acquired by actual use of the mark in commerce to such a degree that the public identifies that the mark originates from a single source for a given product or service. In other words, if there's no actual use, then there's no trademark rights. An example of actual use is if a person is selling clothing and on the tag it has the mark or the trademark in which the clothing is being sold under. That's an example of actual use. Myth number 2. A trademark has to be registered before protection starts. Trademark protection begins when the mark is actually used in commerce, as we stated above. By using the mark in commerce without registering the mark on a state level or federal level, a person acquires common law trademark rights. Common law trademark rights can exist in the absence of federal registration. Common law trademark protection is limited to the geographical area where the mark is being used. Myth number 3. State registration provides nationwide protection. There is no nationwide protection for registering the mark on a state level. State registration of a trademark provides trademark rights limited to the state in which the trademark is registered. So if you register in the state of Illinois, the scope of protection will be the state of Illinois. Myth number 4. Registering my company with the Secretary of State automatically gives me a right to use my company's name as a trademark. Registering your company's name with the Secretary of State only gives you the legal right to use the name for official purposes, such as banking, engaging to contracts, or other legal documents, and taxation. The Secretary of State only cares if the name conflicts with another name registered in the state. The Secretary of State does not look at other states or look at trademark issues. Myth number 5. Since I registered my company name with the Secretary of State, I have to use my company's name as a trademark. There is no requirement to use your company name as a trademark. I have provided below 2 companies that do not use the name as a trademark but have products that they sell under a specific trademark. For example, S.C. Johnson sells Windex, or Johnson & Johnson sells Listerine through its subsidiary. Myth number 6. Before filing a trademark application, I must conduct a trademark search. A trademark search is not a mandatory prerequisite for filing a trademark application. In other words, there are no legal requirements that a trademark search must be conducted. However, it's very beneficial to conduct a trademark search because a trademark search can uncover issues that could prevent registration with the United States Patent and Trademark Office, or uncover issues that can lead to possible trademark infringement. Therefore, it is a great idea to conduct a trademark search or have one conducted. Myth number 7. Doing a Google search or search at Amazon's website is enough to find out if someone else has a registered trademark. An internet search is not sufficient to determine if someone else has a registered trademark. A sufficient trademark search, at the very least, should search for federal trademarks and common law trademarks, such as the United States Patent and Trademark Database and States Database. Myth number 8. I searched the United States Patent and Trademarks Database, TEST, and did not find an exact match. Therefore, I am guaranteed federal registration. No one can guarantee federal registration of a trademark application because all trademark applications are examined. The examination process looks at many different factors, such as the strength of the mark, evidence of actual use, and likelihood of confusion. If a mark is exactly the same or is similar to another registered trademark, the United States Patent and Trademark Office will refuse registration of the mark for likelihood of confusion. Myth number 9. I am free to use the registration symbol as soon as I begin using my mark. Trademark registration symbol can only be used once a trademark is registered with the United States Patent and Trademark Office. The symbol TM, which stands for trademarks, and SM, which stands for service marks, can be used for common law marks. Do not confuse the two between trademark registration symbols and the marks that can be used for common law marks. Myth number 10. My business is too small to need to protect its trademark. By not protecting or policing your trademark, you may lose trademark protection if your trademark becomes generic. Also, you may be prevented from enforcing your rights against an infringer because you acquiesced in allowing an infringer to use your mark. Therefore, make sure that you protect your mark. Thank you for watching this video, and I hope it was very informative.